where we are the victims. And orders have already been passed in 2011. My lords, what they are saying, there are 7 organizations altogether that represent all the victims. There are no other organizations. So we, my lords, are for 5 organizations. The impleadment has happened. We are now parties. So, my lords, what they are saying.
By which order were you made parties?
By 13/4/2011. My lords, they are saying. If I may just finish, then of course you have your chance.
Very specific.
Yes.
In the curative petition.
My lords.
Who is the party?
In the curative petition, I am a party. But it's been allowed, and then it has been said that on maintainability and merits, we will be heard.
We will not permit. I discussed. We will not permit it like this. We are not averse to hearing a point of view. Yes, but we will not let parties be intervened like this. This creates an unmanageable situation.
My lord,
so I have to say something on the basis of the records and previous before us. We are not averse to listening to you. No difficulty on the record.
My lords, very well on their point. My lords, our petition is already there as it has been said. So my lords, if that can then be, we can be heard on the next occasion. We have, along with everybody else or whatever. We are my lords, we are already petitioners. I was only speaking up. I don't want to.
It's not a support actually, because the question is, my lord, for the victims. When we came initially, when Union of India had not filed, my lord, even the review petition, we filed the review petition. We have been, my lord.
What happened to your review petition?
Yes, my lord.
What happened to your review petition?
My review petition was, my lord, that was allowed, and that's how, my lord, the judgment partially, the settlement which was there, my lord. On that settlement, my lord, the directions are given, and one of the directions is this, my lord, and that is where which is important.
Review petition worked itself out or not?
After review petition, my lord, we moved an application. Yes, my lord. Sorry.
Has it worked itself out or not?
No, my lords, they are still absconding. My lord, criminal cases, and they are still proclaimed.
1 second. They are relying upon, Union of India is relying upon the directions which are given in our review petition, which was filed by us.
Maybe.
One important fact I must point out, where 197, what has been said is, where, my lord, in curative petition, the Union of India disputes that, because they say, in case UCC is not able to pay, my lord, then Union of India will pay. Now, they ultimately, my lord, dispute that the finding which is given by majority is not correct. Now, we are not on that, because ultimately it will be adjudicated. But I come in because it was in my review petition, a finding which has been given is being, my lord, questioned in this curative petition. So how do I, my lord, then come in? That's how I come in here.
You are satisfied with the orders passed on your review petition?
No, my lord. You're not.
What did you do?
Yes, my lord. Yes, correct. What I did was.
Did you file a curative petition?
No, my lord. What I did was curative, my lord, jurisdiction came subsequently. We filed, my lord, an IA. That IA, my lord, lordship said you go before the adjudicating authority. We went before the adjudicating authority. Then, my lord, High Court. My lord, may I just finish? High Court, and then ultimately SLP, which is pending here on the same question. After our SLP came that they filed a curative petition. That's how it has happened. So, my lord, we have been pursuing, my lord, the cause of victims from the very beginning. Yes. Now, I leave it to your lordship, my lord. I don't want to say anything. I just want to, my lord, I have prepared the entire thing which we did. That we should be, my lord, we should be heard because of this reason. Because if you are not implemented as a party, any direction which is given, because the direction ultimately has to be binding. And they said they are on our behalf. This petition has been filed by Union of India. They have said this is parents' patria, because under Section 3, my lord, the right has been given under Section 4. The organizations have been given, my lord, the act which was framed after, my lord, after the tragedy happened. Under 4, my lord, we have been given a right to be represented. And what this court said that we committed a mistake in not hearing the victims. Though ultimately this was a little wrong, but for a larger purpose, we are condoning it. Otherwise, it will be a violation of principles of natural justice. In a larger sense, my lord, if you are not heard, then there will be, my lord, I repeat, my lord, it is the same kind of situation which happened then will be happening now. So, lord, I leave it, my lord, victims in lordship's hands to protect us. And, my lord, team, my lord, whatever is proper order should be passed. My submission is, my lord, these are the organizations which are there. We are there from the beginning. Not, my lord, come today. Yeah, my lord, not come today. So, if not, there are certain organizations that are already implemented as parties, we should be implemented as parties.
You represent 5 organizations. He represents how many?
2.
Precisely, my lord.
This is not a serious case, my lord, where the party which files the review does not come in curative. The Union of India does not file the review but comes in curative. The curative is filed after 19 years of passing of the review judgment. And my lord, the criminal curative petition was dismissed by my lords because it was filed after about 17 years on account of delay. Similar curative petition on the same facts was dismissed by my lords, not on delay.
My lords, greatest respect. This is Union Carbide that is absconding.
Just wait. They were actually heard. Yes,
Lord, if I can, Lord, now, Lord, in the order dated, Lord, the first aspect about the implement of Lord's these NGOs, 13th April 2012, Lord's 2011 order. The lordships have raised the question of the maintainability of these implement applications. If the lordships will, Lords, we see that order, it's clearly said, Lord, the maintainability of the implement applications filed by the NGOs is an issue and has to be decided, Lord. Now, my lords,
Was that decided at any stage?
no. This hasn't been decided, my lords.
My lords, let me progress.
Now, what happened, my lords? Since, my lords, the matter was in circulation and the issue, notice was issued, my lord, it said that for open hearing in the court. My lord, the registry has allowed them to be pleaded, my lord, as co-petitioners. My lord, though the Union of India only has filed the curative petition. My lord, curative is an extraordinary, my lord, ceremony that your lordships evolved in 2002. But the reason why, my lord, these NGOs cannot seek, my lords, an independent right for enhancement of the compensation, other than, my lord, Union of India subject to the merits, is, my lord, the provision of the Bhopal Gas Act, my lord, enacted by the Parliament, my lord, after the tragedy. The essence of the Lord Bhopal Gas Act is that the exclusive right has been given only to Union of India, my lords, not to the individual act victims, not to the NGOs, my lords, or the organizations, but all claims in regard to the disaster, my lords, the exclusive right in regard to the damages to the person or the property or anything of the claim is with the Union of India. The constitutional validity was challenged in Charan Lal Sahu. Your lordships and a constitution bench have upheld the act and saying that it's only the Union of India. So, my lord, NGOs today, my lords, and what is happening is applications after applications are being filed, my lords, papers after papers, documents are being done. And now, your lordships have a record of more than 5,000 pages. My lord, we have also filed an application, my lord, saying that these NGOs do not have, my lord, the right of impleement because of the act, also because of the order, and they should not be. This is one aspect of the matter, my lord. On the last date, my lords, with the learned solicitor, my lord, said that he would like to take instructions. The matter indeed came up for, my lord, directions, my lord, because the housekeeping has to be done, my lord, in this case. The voluminous records, compilations have to be prepared. My lords, the lordship said in the, my lord, the circulation that the councils have to indicate as to how much time. Short submissions have to be filed. Timeline has to be indicated. So, my lord, all these things have to be done. Our problem today, my lord, is this, that even yesterday night, my lord, a bunch of papers have been filed by the NGOs, my lords, which is quite unnecessary. The contest is between the Union of India, my lords, and the UCC, my lords. The lordships may, if the Union of India wishes to go ahead, my lords, we can't say anything. But he take the matter for housekeeping, my lord, give the directions, allow us. There are as many as 8 or 9 IAs, substantive IAs filed by them, my lord, for seeking enhancement of compensation to some, how many crores, I don't know, 20, 30,000 crores. My lords, the notice has not been issued, my lords, all those applications, my lords. If they have to be heard, then we have to give a response. So the lordships may decide the issue of the maintainability, my lords, whether they can be co-included as petitioners in the curative petition along with the Union of India. They are virtually, my lord, trying to become co-plaintiffs. That's what
I just want to add, just to add to that, my lord. First, before the NGOs come into the picture, your lordship will have to decide, my lord, whether the jurisdiction of curative was not there at the time of passing the review petition, whether the curative petition is at all maintainable, number one. Number two, Union of India did not file a review. They were satisfied with the first judgment. Now, by skipping the review, whether they can file the curative. Number three, my lord, the delay of 19 years after passing of the review judgment. 19 years. 91 was the review judgment. Union of India filed the curative in 2010. And thereafter, my lord, as I said, my lord, criminal curative has been dismissed. And there are so many other, my lord, maintainability issues of the Union of India's curative petition itself. Your lordship may be pleased to decide that first before coming into the issue of the NGOs. In my respectful submission, there is enough material to, my lord, dismiss the curative.
Just one minute. One thing, my lord, which I forgot.
Review was, my lord, decided in open court of hearing.
Which I forgot to mention is this, my lords. In 1999, this was a court negotiated settlement, my lords, by a constitution bench. 470 million, my lord, US dollars, which translated into 3,000 crores, my lords. 1991, my lords, a review was entertained by a constitution bench, my lord, presided over by his lordship, my lord, Justice Venkat Chalaya. Hearing went on for 88 days, and there were only 2 issues, my lords. One was the adequacy of the settlement amount, $470 million, and the second, my lord, where the criminal proceedings were quashed. The constitution bench, my lord, in the review petition decided that this aspect of the adequacy of the compensation